Welcome to J is for Justice podcast. If live breaking news and following true crime is your thing, then please consider subscribing to my channel. And if you like what you see in my videos, please consider giving them a thumbs up. Well, that was kind of jacked. Welcome to J is for Justice. I had to start a new feed today. Hey, Fry Style. I had to start a new feed today. The other one wasn't working because I made it on my phone. I didn't know you couldn't access those on your computer. So we are waiting for Scott Peterson to be in court. Let me turn up some volume here. It looks like we still have the music playing. Let me just step away for 1 second. I'm going to fix something on my computer. I will be right back. Welcome, everyone who is joining. We are watching or waiting to hear. I don't think we're going to have anything but audio, but we're going to hear Scott Peterson's hearing in just a few minutes.
All rise, come to order.
All right, good morning.
Good morning. Now take your seats, court's now in session.
All right, thank you. We have the public line that is open. We have Mr. Peterson appearing via Zoom. I would just note that anyone who is viewing the proceedings or hearing the proceedings electronically, you are not permitted to record or by a tape recorder. Thank you. All right, so calling the matter of the people of the state of California versus Scott Peterson, please appearances, starting with People's Counsel.
Margaret Flatiger, District Attorney for the people.
David Harris for the people.
Good morning. And for Mr. Peterson.
Good morning, Your Honor. Pat Harris on behalf of Mr. Peterson.
All right, thank you. And Mr. Peterson, as we have in the past when you're appearing via Zoom, first of all, can you hear me? All right. If for any reason, technology fades and you can't hear the proceedings, please let me know. Signal. And we'll have the court reporter read back what we've been saying and catch up. But I think the technology has worked before, so let's hope it continues to. All right, couple of things. Number one, I have received, with respect to Mr. Patrick Harris's request that he be appointed as counsel by the court for Mr. Peterson. We're here today. I asked for declarations. I've received a declaration from Laura Arnold, who is the Stanislaus Public Defender. The court has also received a declaration from Mr. Bruce Perry. And Mr. Perry of Perry and Associates is the alternate indigent defense firm in Stanislaus County. There are conflicts for both of those parties that are established now in the record, and on that basis, the court will appoint Mr. Pat Harris as Mr. Peterson's attorney for all purposes in this proceeding. I'm saying that because we still have the habeas. So as Ms. Arnold pointed out, if the habeas were to be granted, then it would be a retrial. And Mr. Harris, you would be appointed for that purpose as well. So we have that. I've also received Mr. Peterson's Form CR 105, and I do find him to be to have established indigency, and so the appointment of counsel for Mr. Pat Harris is necessary under the penal code. All right.
May I address the court on that issue?
You may.
Thank you, Your Honor. What my request is going to be is that I ask the court if it will not pro-tunc it as, so that it will apply from the period when this started, so that we've put in the last 7 months, we've put in considerable time and expense. I've discussed that with Mr. Perry. He's agreed that we can come up with some figure that would be somewhat reasonable or whatever, so that we can deal with the issues of what's been done up to this point. So I would ask the court if it would agree to not pro-tunc it to that point.
All right, the court will, the order will be non-pro-tunc to, what was the date that you appeared with?
October the 18th, I believe it is.
October.
Double check on that, 1 second. October 23rd, I'm sorry.
Okay, October 23rd, and that was the first appearance at the arraignment after remand.
Thank you, Your Honor.
Yes, all right. Is there anything else I need to deal with, so we're not back on this issue, in terms of Mr. Pat Harris, the fees? I'm assuming, but I should ask, that those fees, you've worked them out with Mr. Perry in terms of what fees you will be paid for your services in this case. Is that correct?
That's correct.
All right, thank you. All right, second matter, people have anything to add?
Only that it looks like Mr. Taro might have unmuted himself there briefly. I don't know if he has anything to add.
Thank you. Mr. Berry, do you have anything? I'm sorry. Yeah, are you unmuted? You're still, you have to increase the volume. So you're fading in and out, so we're going to have to get the volume fixed first. We still can't hear you. Mr. Berry, if you wish, we can give you a number. Can we get Mr. Berry on a phone?
It's actually Mr. Taro.
Oh, Taro, I'm sorry. Mr. Taro, thank you. Is there a number that we can call, Mr. Taro? So we'll have you, I'm not sure if it's going to work.
I think I have a number for him in my phone if he doesn't speak up.
Okay, just a moment, Mr. Taro, thank you.
So I have a number, but it is a personal cell, so can I just show it to whoever needs the number?
Yes,
I have his work cell.
thank you. Just a moment. Yes.
Okay, thank you. Sorry for the technological problem.
That's all right.
What I was going to say is, Judge, I'm not aware of any prior arrangement with Mr. Harris and Mr. Perry with regard to the time since October. I'm not sure that it's appropriate to make that order. Mr. Harris had not been appointed at that time.
Well, here's the court's concern. Mr. Harris has put in, he appeared He's had discussions, as I understand, with Mr. Perry, and he has done work on the case. And from what I understand, he and Mr. Perry you've worked out an arrangement in terms of the fees that have been incurred to date. Is that correct?
What we did is we had worked out an arrangement for the entire retrial. We had worked out, what we had done, just to give the court a little background, is we had determined approximately the number of hours that would be involved in terms of the entire retrial. At that point, what we determined was that it would be extremely expensive for Stanislaus County to pay by the hour, because this case with the retrial would be, ultimately the fees, even at a very low hourly fee, would be astronomical. So what Mr. Perry and I came to was an agreement on a flat fee, and that's what we had agreed that would begin from October until the end of the retrial. So we came to that agreement. Then we had this issue over the appointment, which started when Mr. Perry needed to provide them the appointment order. And then we went through this whole thing. Mr. Perry and I had a conversation, I believe it was on Tuesday of this week. I explained to him that I was going to ask the court to nunc-pro-tunc it. He said, that's great. If the court orders it, then call me back and we will work out an arrangement. It will be somewhat similar. Instead of charging for hourly, because we have put in literally hundreds of hours at this point, instead of charging hourly, he said, we'll just do the same thing. We'll do a flat fee basis. So we did not come to an exact amount, but we've come to an agreement that, based on the court's order to nunc-pro-tunc it, that we would do the same thing and we would do a flat amount.
So, Mr. Terrell, what's the authority for the county essentially saying that the court should have Mr. Pat Harris work for free? He's done work on the case. He appeared. There's clearly a conflict. I mean, that's been established now. So I'm not understanding why you're raising this issue about the nunc-pro-tunc when clearly both the Stanislaus on the hierarchy, when you have a defendant who cannot pay for his own counsel, first, it's the public defender's office. That office now has established that there's a conflict. Second would be conflicts counsel. Mr. Perry has established that there's a conflict. And so Mr. Pat Harris, who's familiar with the case, the county's not paying for someone else to get up to speed, which is what the county would have to do if there was someone else. But this is an attorney who has historical knowledge about the case and I'm not understanding where you're coming from when you're saying, Judge, you should not nunc-pro-tunc your order when clearly the conflict that is before me now and established existed back when, in October, when Mr. Harris came in and said he was private counsel for Mr. Peterson. So do you have any legal authority for me?
You know, Judge, off the top of my head, I did not, because I was not aware that there was an agreement that make it nunc-pro-tunc. I've been in regular contact with Mr. Perry, so what I would recommend or suggest, rather, or request, is the court just notes our objection, we make the order nunc-pro-tunc, and then if we need to do something else, we can handle it appropriately. I was not aware that that had been part of the discussion with Mr. Harris, and I understand if the court's satisfied with this declaration, that's the path going forward. I just wasn't aware that there was an agreement in place for that time when Mr. Harris had not been appointed. So if the court would note over our objection and make that order, and then that'll be that.
All right. The court notes that county is objecting to the order being nunc-pro-tunc, but again, the court has established by declaration that in fact conflicts exist now that would have existed back in October, and Mr. Harris would have been, had we gone through this exercise in October, he would have been appointed, and so I am going to make the order nunc-pro-tunc, but your objection is noted for the record. Thank you so much.
Thank you, Your Honor.
Okay, anything else on the appointment issue? No. All right, so we have a couple of other matters. The court received from, in the file, the counsel on the writ is going to be filing the denial on June 25th. So we're not going to have a status hearing on June 21. I had put that in just in case there were some issues, but I'm satisfied. I'm going to be, in fact, I signed an order today, and I'll give counsel copies. So we will not have a status hearing regarding the filing of the denial for the writ on June 21. That is vacated, and I'm providing copies of that order to counsel here, and we will mail and serve Mr. Farkas and the writ counsel with that order. All right, last thing is the time waiver sentencing. So right now, we have the District Attorney's Office who has filed a decision not to seek the death penalty in this case. So the only outstanding issue is sentencing for life without the possibility of parole. And I know at the last proceeding, there was some urgency that the district attorney expressed in wanting to set that sentencing hearing. So now that Mr. Pat Harris has been officially appointed, we can get to that. So,
Thank you, Your Honor. Our position is that the defendant currently sits on death row, and he's not eligible to be on death row. And it's appropriate to go ahead and set the formal sentencing. The family has indicated that they likely will make statements. We believe the matter needs to get referred back to the probation department for an updated report, unless the defense waives that requirement. So that's our position.
very well. Mr. Pat Harris.
Our position is that there is no either legal or practical reason to rush the sentencing at this point, given the fact that the court is still looking at the potential for a retrial for a number of reasons. First, I would state again, there is no reason, there is no legal good reason that it has to be done. He's been sitting there for 18 years, and another few months is not going to make any difference whether he stays there or not as far as the state is concerned, as far as sentencing is concerned. It does make a difference, however, in terms of the defense. The first thing it makes a difference is that Mr. Peterson is participating with his appellate attorneys, as I understand it, on a regular basis as far as the retrial, the brief that's being filed with the court, what will certainly be, I would assume, will be a hearing. I may be wrong, but I believe a hearing is required. So he's going to need to be involved in all that. He has access to his appellate attorneys. They have set it up through San Quentin so that they have easy access to him, both by phone and now by visitation. If he gets moved, we have no idea where he's going to be moved. He could end up in Southern California near San Diego, somewhere like that, if he's moved, and make it very difficult for them to have access to him. That's, I think, an extremely important thing, because he needs to be able to participate in his case. That's part of the defense, is to have him participate.
So, one moment. When you say, so the record's clear, appellate counsel, Mr. Sandusky and Mr. Farkas appeared for the habeas part. So there was an appeal, and I understand there are different appellate counsel than counsel for the writ. So I want to make sure the record is clear what you're discussing, Mr. Pat Harris. Is that?
I appreciate that, Your Honor. Yes, thanks for that correction, yes.
So you're talking about Mr. Farkas and Mr. Sandusky, who are with
habeas counsel, yes.
habeas counsel. Okay, thank you.
So he is participating, I understand from speaking to them, he is participating actively with them in terms of preparing for any hearing, and by moving him would make it extremely difficult. Perhaps, like I said, he could be moved anywhere, perhaps somewhere where it would make contact virtually impossible. The second thing is, and I think this is important, obviously the court hasn't had a hearing, hasn't ruled on the retrial. We don't know what the circumstances are. But a sentencing hearing is going to, once again, the court knows that this case has drawn a great deal of publicity. We had that issue last time where we had so many jurors who came in and were familiar with the case and what had happened. A sentencing hearing is going to put a great deal of publicity back out there, and a lot of it's going to be in the family, and they certainly have the right to make statements. We understand that. But that's going to draw a lot of publicity. There's going to be a lot of things out there, again, that are stated, And if there is a retrial, it's going to make it very difficult again. It's going to add to that. I'm not going to say it's going to be the number one factor, but it's going to add to that sort of atmosphere that made it difficult to pick a jury in the first place. The one positive we have, if there is a retrial, is we are 18 years later. And certainly some of it, the publicity has died down, some of it is calmed down to a certain extent. I don't see a reason to try and ramp it back up prior to a potential for a retrial for essentially no reason, no good legal reason. And the third thing is we're talking about putting the family through, as well as Mr. Peterson's family, through another sentencing hearing, which is emotional and difficult, and I certainly understand the Roaches, it'll be very difficult on them. Then potentially having a retrial and doing a sentencing, if he's found guilty, a third time. That doesn't make practical sense to me. We have no reason to push this prior to the retrial. We have a lot of reasons not to push it prior to the retrial. And
Well, you're assuming, you're saying prior to a retrial. I want the record to be clear. The writ, the denial of the writ on the, so the writ of habeas corpus has not yet been decided. All right, so once the denial is filed, there's a 60-day window within which this court either decides it on the papers or sets it for a hearing. All right, and then after the hearing, then there's a determination if there is a hearing or on the papers. So that's basically where we are. So I do understand what you're saying, and the court said at the previous hearing, and Mr. Farkas was here, that if there is going to be a hearing on the writ, an evidentiary hearing, it's going to happen in 2021. It's not going to be delayed. So I'm looking back to the district attorney's office. I'm assuming, but I'll ask, Mr. Harris, that your client would be willing to waive time for sentencing because there's a statutory obligation that the court sentence the defendant within a certain period of time. So I'm assuming that you've discussed that and that he would be willing to waive time on the record today.
yes, Your Honor, he would, and I think our request would simply be exactly what Your Honor said is, let's come back for another status hearing in 60 days when the court has determined whether or not there is an order at that point or whether there's going to be a hearing, and then we can determine, again, if the court has made the order, then we can, depending on what happens, we'll know. If not, then there's going to be a hearing. We can put another status until after the hearing and make a determination then. I don't see that there's any reason not to do that. It just seems logical to me. Let's find out what's going to happen. We can keep coming back, and let's see what happens and what the court decides.
Very well. For the district, yes.
Excuse me, just to add some thoughts to this. Legally, at this point in time, Mr. Peterson is an unsentenced inmate, so he has been convicted, but technically he has not been sentenced. So it's unclear whether CDCR actually has jurisdiction. I don't think that they're going to release him or do anything with him. I don't think he'd be sent to some other institution. They're going to keep him where he's at until there is an order from the court. If the court accepts Mr. Pat Harris's proposal, which is to waive time and put sentencing over, we still have the issue of there is the probation report. If the court, again, we're trying to keep the writ and this appeal process separate, but as the court was just mentioning with the writ, if there was some further proceedings that happen in real life instead of just a paper decision, Mr. Peterson would have to be brought back so he could participate if there was an evidentiary hearing or if there was something along those lines. So at some point in time in the near future, it should be anticipated that Mr. Peterson's going to need to be brought back to San Mateo. And it would be our suggestion that he be brought back because regardless of what happens on the writ, there is still the probation report. So having him here would allow probation to do their required duties to prepare an updated report. We don't need it until we get to sentencing, but at least we wouldn't have another continuance to bring in here for them to do the report, for us to have to come back again by the court considering bringing him to San Mateo at this point in time. And then Mr. Pat Harris would not have to worry about CDCR sending him somewhere else. He would know where he's at.
I appreciate what he's saying, but I don't think, I don't say this about the court, I don't think any court has the ability to determine that or order that. I could be wrong on that, but I think, they make their decisions in terms of their housing, especially with a convicted, with somebody who's not been sentenced. I don't know that, honestly, I'll have to tell the court, I know, for example, the Bureau of Prisons federally, the court has no authority. They can't tell the court to do anything.
That is accurate. So the court can make a recommendation, but that's all the court can do. And I think that, well, it's premature at this point, but how long would it take for the probation department, because it would be Stanislaus Probation Department, San Mateo? Okay, how long would that take to have a?
Unfortunately, I couldn't say that we're any experts on how San Mateo does their sentencing, but I do know from our county, our probation department asks for as much time as they can get. And I see someone agreeing with us on that one.
Okay, so,
Well,
Madam Clerk, yes, I just need to look at a calendar, I apologize. And I have 2020 up here, so I need a 2021 calendar, please. I see up there. Okay, thank you. Why don't we come back in the fourth week in August, the week of August the 23rd? And here's my thought process on that. And I'm willing to listen, Mr. David Harris and the district attorney, to your position. So probation is going to, if the court orders that they start preparing a probation report, which the court could do today, and then when we come back, the denial is going to be filed on the writ on June the 25th. Again, the court has 60 days, which would be, not precise on this, Madam Clerk could tell me, but August 25 would be the 60 days for the court to make a decision as to whether or not it would be decided on the papers or to set an evidentiary hearing. So my thought is, if we come back, there'll be some clarity about what's going to happen next. And then we could, I think more appropriately raise the issue and get some certainty as to a date. That's the best that I can say, just because of the posture of the case at this point with the writ outstanding. But that's my thought process. I don't want to hold things up. I'm also sensitive to the fact that right now, Mr. Peterson should not be sitting on death row. Okay, that was overturned, number one, and I've raised that issue several times when I've been on the bench in terms of his being moved. Not this court's decision, that's the decision for the California Department of Corrections, but nonetheless, now that the district attorney has filed a determination that they will not be seeking the death penalty, and so we're not going to have a retrial on the penalty phase. I don't know what the CDC is going to do, but at the end of the day, we're going to have to make a determination about sentencing right now. We don't have to make a determination right now, but I think we can do it more thoughtfully in August.
That's fine, Your Honor. It's been our position that basically it's CDC's call. They're going to do what they're going to do. And at some point, they may physically take him off death row and keep him at San Quentin. They could keep him on death row. They could take him off death row and move him to another prison. And, obviously that's not what our preference is, but our position sort of is we're just going to leave it up to them to make the decision.
Well, I don't think anyone has jurisdiction over the CDC except, so
Yeah.
why don't we do that then? So we could get out calendars, and then I am going to ask for your client's waiver of time until we come back.
If I could make the request, Your Honor, if we could do it the 25th, I actually leave the country on the 20th. Your Honor, if we could do it the 25th, I actually leave the country on the 26th. So if we could do it on the 25th, is that possible?
Yes. Okay, so August 25, does that work for the district attorney?
I'm checking really quickly here.
It's a Wednesday.
Yeah.
If there's another day earlier that week, I'm fine with that as well.
The 25th is fine.
All right, so we'll do August 25 at 10 o'clock. And again, if your client, I know with COVID, that's yet another factor that has been present. So with COVID, your client has appeared on Zoom. If you want him to be here, Mr. Harris, on the 25th, just present an order for transport and the court will sign it, but that is a discussion between you and your client.
Thank
All
you.
right. So, Mr. Peterson, sir, can you hear me? Have you been able to hear everything that's been said? I'm sorry, we can't hear you, Mr. Peterson. We can't. Just a moment, sir, sorry. We can't hear you. Have they cleared up the technological difficulties? Here's what I'm going to do, Mr. Peterson. Mr. Harris, have you discussed the issue with your client about waiving time for sentencing?
I have, Your Honor.
And are you satisfied? Well, will he agree to waive time until August 25 to set a sentencing date?
Yes, Your Honor, you will.
And do you have any reason to believe that anyone has coerced him or otherwise made his agreement to waive sentencing until August, or setting a date for sentencing until August 25th?
No, Your Honor.
All right. What I would like, please, can you secure just a written waiver so we have it in the file? All right. Mr. Peterson, I won't have to voir dire you. We have technical issues, but I voir dire your attorney, and I'm just going to ask him to follow up with a written waiver from you so we have it in the file about waiving time for sentencing. So our next hearing date, or status, I should say, is going to be August 25, and at that point, the court may set a date for sentencing. In the meantime, to the extent that probation is able to start preparing a report for sentencing, then probation should do that. I am not sure, Mr. David Harris or the district attorney's office, if you've been in touch with probation about to begin the preparation of the report.
We have not. Traditionally, what happens, and when the court sets it and there would be a minute order that's prepared, that would be shared with probation, which starts them on their path. But we will start that ball rolling without the minute order at this time.
All right. And Mr. Pat Harris, is there any, do you wish to be heard? I intend to sign an order to just get probation moving, so we're going on two tracks. That's really what I want to do.
We have no objection to that, Your Honor.
Very well. So the court will sign a minute order asking that San Mateo County Probation Department please begin the process of preparing a sentencing report in the matter of the people of the state of California versus Scott Peterson.
Your Honor, would you like probation to appear on August 25th?
Yes, please. Anything else that we need to do today?
Your Honor, just for the record, if it could indicate when you were asking Scott Peterson if he was willing to waive time for sentencing, we can see him on the screen. We couldn't hear him. He appeared to be speaking, and he appeared to be nodding his head in the affirmative. So just so the record reflects that as well.
Mr. Pat Harris, agree with that?
I agree with it.
All right, very well. So the record will reflect that there was a nod affirming the waiver, although we had technical difficulty. But that's the reason the court is also going to secure a written waiver that will be in the file. Can you do that by the end of the week, Mr. Pat Harris? Yes. All right, thank you. So I think that will take care of it. But thank you so much, and we'll see everyone on the 25th. Thank you.
Thank you, Your Honor.
Oh, yes, oh, yeah. There's other people on there, so.
Okay, guys, so let's talk a little bit about why we are where we are. I see a lot of people are like wondering and a little confused. So the first thing is that Rochelle Neese was a juror on Scott's original trial. She lied on her jury questionnaire about being involved in any kind of a domestic court hearing or orders, anything like that. Like if she's ever been involved in a domestic in court. And she stated no. But she had, because his sister-in-law, Janie Peterson, has always believed in Scott's innocence. She is married to Scott's brother. So Janie got the discovery, and she got a team together from online, and they went through the discovery with a fine-tooth comb. And what she discovered was not only Rochelle Neese's false questionnaire, but she also discovered that there was evidence and witnesses that the investigators never followed up on. Some of those witnesses state that they saw Lacey walking Mackenzie, the golden retriever, at the same time that Scott was at the fishing pier or the bay. So they never talked to these witnesses. These witnesses came forward with their statements. I saw her. There's like at least 3. And then there's another thing that Janie is pulling out of her back pocket, and that is the robbery across the street. So that morning, at the same time that Lacey went missing, there was a van parked right across the street from the Peterson's house, and there was a robbery going on in that house. The neighbors were out of town. Another neighbor had driven by at that time and saw the van and saw the men outside the van. And she looked over at them because she thought it looked sketchy. And they looked at her and she was afraid. She felt like, ugh, you know. And there's been numerous people that have said that Lacey, if she saw something going on, she would have said something. So the fact that they didn't question these witnesses or take their statements is, I think, the main reason that they're asking for a retrial. Because if those witness statements prove that he's at the fishing thing, and these 3 witnesses actually saw Lacey Peterson, and the jury believes these 3 witnesses, then Scott would go free. if the jury believed these witnesses, but the jury never had an opportunity to even hear these witnesses, and that's why it's not fair. So whether you believe he did it or not, the jury still should have heard from everyone on all aspects of the case, not just one narrative. So that's why they screwed up. And if anybody's going to be angry at anyone, they should be angry at the investigators for not following up on everything. Because when they don't do that, this is what happens. So we've already got the death sentence overturned. I mean, whether he gets a new trial or not, he's in prison. Hi, Lisa 1111. He's in prison for the rest of his life right now. So his sister-in-law and all that evidence, and now the new attorney he has are saying, hey, hold up. We need a new trial because the first jury didn't even get all the information. And second of all, one of the jury members lied. And then she gloated afterwards. It was a really gross shit show after his trial. Lorraine, thank you for becoming a member. Welcome to the J for J fam. Well, the thing about that too, Annette, is another point that Janie makes. Janie Peterson says, hey, investigators released where Scott was right off the bat. I'm not saying he was set up. I'm saying there's room for doubt. So if you come out and say, like, how many times do we hear when, they're investigating a murder? How many times do we hear law enforcement tell us details right away? We don't. We're always frustrated because we want the details, and then we listen to these pressers and they're like, we can't discuss anything. This is an ongoing investigation. Why would they give away Scott's last location right away? It makes no sense. It really doesn't make any sense to me anyways. So if you guys want to catch up on what Janie Peterson has found, what she's done, there is a documentary. I believe I watched it on Amazon. And I can't remember what it's called. There's several Scott Peterson documentaries on Amazon, but this one in particular is newer. So if you want to check it out on Amazon, you can watch it there. I found it very interesting. I did not know these things. I followed this case when it happened. So, I was all about this case with Nancy Grace and Greta Van Susteren and back in those days. So I did not know because nobody knew Strawberry Shortcake lied, aka Rochelle Neese, until Janie Peterson uncovered it. And in this documentary, Janie shows you her office where she has all this stuff, boards on the wall. She's got binders and binders and binders of discovery and cork boards and notes. And it's just insane. It's insane. So she must really, really believe in her brother-in-law's innocence or the fact that he did not get a fair trial. And that's the thing. If these bases aren't all covered and things are swept under the rug, they can creep out later. And then you've got the victims being victimized all over again. And this is why investigators need to do a thorough investigation. I mean, nobody can control that Rochelle Neese lied, I guess, except her. But the not questioning of witnesses, if they were so sure it wasn't Lacey, why not just put their statements in the discovery and call it good? Was it laziness? Was it they just didn't care to talk to them? I don't know. Yeah, Flyboy. Everything stacks up against him for sure. But it still does not mean that he can get an unfair trial and everybody should be okay with it. The victims should demand that a fair trial is done the first time because they wouldn't have a problem like this. It would be sealed, What did Mad Marsha say? I can't find her comment, but oh, yeah, the home surveillance cameras we have now, this would never happen. But yeah, unfortunately, eyewitnesses are not the most reliable, even right away, let alone 18, is it 18 years later, I think? 18 years. Wow. He's been sitting on death row for 18 years. But what if it was the robbers? I mean, let's think on the opposite side of the coin and let's think, what if it was the robbers? What if she went over there raising Cain and they grabbed her? And then they heard that her husband was last seen fishing on the bay. I mean, they gave his exact location, what fishing dock or whatever he was at. So it's possible is what I'm saying. Like, I'm not saying it's probable. I'm saying it's possible. And I just think cases like this should be sealed, like airtight, no room for any error like this. Yeah, I mean, exactly, Shell. I mean, we got to think objectively and think about, like, if this was your family member. Imagine if this was your brother and you didn't think that he really did this. I mean, there should be no room for questions. It's not like they're pulling stuff out of their butt. This is, legit. Like, she lied. The juror lied on her jury form. And in my opinion, she should be prosecuted for that. Because she was a smartass during the whole trial. I just don't think cases like this, there's any reason to celebrate anything. And this is just my opinion. But the mockery that they made of that trial and, whatever the result was, the justice in that trial, they made a mockery of it in press conferences. She was out there screaming like she's in a gang. It's like, I don't know if you guys have ever seen that, but she was very, very crass. Hey, I am not here to argue Scott's innocence or guilt. I'm just bringing you the news. I'm bringing you what I've heard, what I've seen, what I've read, and I'm just bringing you both sides of the coin, you guys. You got to think about both sides because both sides exist. You can't just think about the side that you're on or you agree with because there's always another side. And we don't have to attack each other about that. We can discuss, we can debate, we can put our reasonings out there for why we feel the way we do and still be respectful. I mean, right, if Casey Anthony can be found not guilty, Scott Peterson has a shot. You have to admit. So I'm asking you guys to go on Amazon and watch the documentary with Janie Peterson. I'm going to show you guys a clip from it right now. Let me find a good one. Okay, here's one where Janie... Okay, this is on the Modesto Bee, and this is where Janie Peterson speaks about Rochelle Neese. And this is a minute long, so we'll watch this real fast. I haven't seen this either, so... All right, here we go.
For convicting Scott, and on her jury questionnaire, she was asked, have you ever been a party to a lawsuit? Have you ever testified in court? Have you ever been a victim of a crime? And she answered no to all of those questions. And it was found that the answer to all those questions was actually yes. And the circumstances surrounding that was that she had been assaulted while she was pregnant by her boyfriend's ex. And she feared for the life of her unborn child. So that would have been something that the defense should have had a right to know and excuse her as a juror if they'd had that information. The jury questionnaire should have been completed properly, and that's the problem. It wasn't. So.
Okay, so that was Janie Peterson speaking about Rochelle Neese, aka Strawberry Shortcake. And now we have her talking about the evidence. Whoops. The evidence that she found. So let's watch this one.
Walking her dog have to be wrong. And then in addition to that, you look at the evidence in the home that she was alive that morning. You know, she's using the computer, she's curling her hair, she's mopping the floor. She's putting the leash on the dog to take the dog for a walk. You know, these things are all evidence that she was alive the morning of December 24th. If he staged those things, why isn't he drawing attention to them? You would have him, first off, dressing her after he kills her. So he's going to dress her, put her necklace on, her earrings on, her watch on, her tennis shoes on, put her pajamas in the hamper. Then he's going to sit down on the computer and pretend to be her. He's going to plug in her curling iron and drag her bench down the hall and pretend to be her. He's going to fill the mop bucket to pretend she's going to mop. He makes up a conversation about what shopping she needs to do for Christmas Eve brunch, and it turns out that he's right, that she still is missing an ingredient. He's staging all these things. And yet that night when the police arrive, he doesn't point it out to anyone. He doesn't point out the curling iron and the bench. He doesn't point out the computer use. When he comes home, the first thing he does is take the leash off the dog. So that doesn't go with that scenario.
All right, what do you guys think? What do you think of that? I think I have one more to show you guys. Two more. Here is Janie talking about visiting Scott in prison.
We visit Scott pretty regularly. I think for the first 8 years or so, we had someone up there every week. You know, Jackie was healthy then, and, you know, slowly that kind of started to slip. But we definitely have somebody up there every week or two at this point. For condemned inmates in California, if you're convicted of murdering a minor, you cannot have a minor visit you. So our children couldn't go until they were over 18. That was the case for Scott. Because he was convicted of murdering Connor, he couldn't have any minor visitors. The entire time between his arrest and until he was at San Quentin, we didn't touch him. It was a full 2 years of visiting at the county jails where there was no physical contact at all. You know, we sit in a cell with him. There's vending machines. We're able to purchase, you know, food, and he can get magazines, paperback books. He can have CDs. I think there's limits on quantities of everything. You can only have so much paper in your cell. You can only have so many CDs.
Does he know about this interview that you're doing with us?
He does.
What was his input on it?
I think he's grateful. He's grateful that we're speaking the truth on his behalf.
Okay, I understand. It's hard to watch a bleeding heart for Scott Peterson, isn't it? It's hard to watch that. It's hard to see someone sticking up for him. But in the end, it's nothing to celebrate whether he gets death row, whether he gets life. there's really nothing to celebrate because, like someone just said in chat, there are two families that are torn apart, and there's a family that will never see their daughter again, their sister, and there's no reason to celebrate. I just don't understand that. That has always rubbed me the wrong way, but I've never been a victim of a crime, and I've never had a family member be a victim of a crime. So I'm saying that I've, coming from a place that I've never gone through anything like this. So I'm not judging. I'm just saying I don't understand it. Hopefully I never have to understand it. I think he's doing just fine on death row, honestly. They were trying to get him back to, it was either San Mateo County Jail or the Stanislaus County Jail. And his lawyers at the time, Mr. Harris, was fighting that. He didn't want to come to county. But if he gets a new trial, I mean, he's all about it, I'm sure. But he didn't want to see, he knew, like they knew it was going to take a long time through these hearings. I mean, here we are over a year now into just hearing after hearing and really no progress, a bunch of confusion because they're not even sure if he's going to get a new trial. He definitely is getting a new sentencing phase, but there's been like 3 different judges involved in this and no one knows what's going on. Yeah, the death row celebration or the execution celebrations, it's icky to me too. I don't like that. I mean, that's just my opinion, but I just feel like it's just tragic all the way around that these things even happen. Whether it's a domestic or a serial killer or whatnot. I mean, no one deserves to have their life taken from them. And an execution to me is just a reminder of that life that was taken. And I just don't feel like I said, I'm not coming from a victim standpoint because I've never been a victim. But to me, as I stand now, it just doesn't feel like I would feel vindicated by someone else's death. And I've heard that from a lot of, victims speaking publicly since I've been doing my podcast. The Rusek family, for example, Mrs. Rusek spoke out adamantly against the death penalty. She did not feel right having the death of someone on her shoulders, and that's how she pictured it. And I understand that. And it's such a personal thing, but okay, so I have one more video I want to play you guys for yous. This is a clip from Oxygen Channel. Credit to Oxygen. And this is Janie Peterson, and this is in May of this year. She says, that she thinks he could be exonerated. Now, this is going to get you guys riled up. I'm getting you guys riled up on this Friday. You're already worked up in chat, and I think there's a little delay. You haven't even heard what I said yet. Yes. Please hit that like button. Take a quick second. You don't even have to leave chat. Just hit the little X, hit like, and then down at the bottom, come back to chat. It's quite easy, I say, mate. Alrighty, here we go. Got it. I even muted the ad so you guys didn't have to listen to it. Isn't that sweet of me? The Modesto B. No, this is Oxygen. That is not what I wanted to play. I'm so sorry. Oh my Lord. Hold on. Yeah, I didn't want to play a music. I did not want to play a video from Oxygen that had no words in it. Oh, this is a good clip. Okay, I found an even better one. And this is compliments of the Modesto bee. Bzzz.
I am a timeliner. I've always thought sequentially. So I think ultimately that was probably where it started with me, like, just trying to piece together the day. The biggest part of what we have in the Scott office is a timeline of December 24th. That kind of takes over one wall. On the board, we just have a very, very small representation of some of the cards that we've received over the years. And that kind of support is one of the things that's really kept our family going. One of the other reasons that room exists is also it really helped us compartmentalize this, because it can take over your life. After the trial, when I sat down to kind of piece together his day, I was actually stunned. I was already stunned that he was convicted on death row, but then I was further stunned at how full his day was, how there was no contradiction in it, and how it could be perceived that he had any time to do criminal activity on this day. And I think the verdict they made was an emotional verdict based on adultery evidence. I think the pile of evidence that showed Scott was an adulterer was used to convict him of murder. We have an innocent brother on death row, so the justice system doesn't always get it right. And we're still in the justice system. We're in the appellate part of the justice system, but this is a much longer path than getting it right the first time in the trial. It's a very long process to overturn a conviction. I think it had an impact on all our health in some way or another, but I actually had a visit scheduled with Scott the day that Jackie passed away. I think her disease progressed at a faster pace than it would have if all of this wouldn't have happened. I think it was a Wednesday that she kind of fell ill, and I was scheduled to leave early the next morning to visit Scott. It was a hard day. All I could remember was when Mark, I think it was in the penalty phase, and we were asking the jury to give him life without parole instead of the death penalty, and Mark was saying, life in prison for the rest of your life is no fun. He goes, there's going to be a day that a guard knocks on your cell and says, Peterson, your mom's dead. And then he's going to come by and knock, knock, knock. Peterson, your dad's dead. And when that day came, it was a hard day. I don't know if you can understand how Lee's holding up unless you understand this injustice. And as much as kids feel it, I don't even know that I can put myself in Lee's shoes as a parent, or in Jackie's shoes as a parent, or in Sharon's shoes as a parent. Just can't even comprehend. Scott needs a new trial, and we need justice for Lacey and Connor. It's not justice for them when Scott's sitting on death row. We watched them grow up when they first were dating, and just watch that progression of life of them starting to plan a family, and that's why they moved to Modesto, was to start a family. Everything we've learned the last 15 years has either confirmed Scott's innocence or taken us one step closer to finding out what happened to Lacey and Connor. And whoever did this to them is still out there.
Okay, much thanks to Oxygen for that clip. I know it's very difficult to listen to. I see a lot of comments in chat. Delusional. She's got a crush. There's something wrong. It's hard to listen to that. After all of the gruesome details of Lacey and Connor when their remains were found. Lacey's mom didn't even get her daughter back whole. I mean, that's really, really hard to get past. And do you guys think that maybe these families are sometimes just in such deep denial that their family member could do something like this, that they carry this, I don't know, this burden around just because they can't deal with the truth? I mean, I've seen it happen. Lacey was very, very pretty. Very pretty. And I've got to say, even since I watched the case and everything back in the day, she definitely had her mother's smile, and every time her mother would smile, it was like Lacey. And it was just so sad. Her brother, I mean, they were so close. They were a very close family. So if you guys, if you want to catch up on this case and you don't know too much about it, or you want to just refresh, I do have a pretty good size Scott Peterson playlist. I do a timeline, I believe. There's a backstory on the case, different things like that. So check out the playlist if you're just doing things around the house or at work and you got your earbuds in. Check it out. But thanks for joining me, and we will be back on August the 25th for Scott Peterson's next hearing. Seems like ages away, but it'll be here before we know it. Everybody, stay safe out there. You guys have a great weekend if you don't hear from me, and be safe.